Awesome. So welcome everyone to our April topical. Today we have, I'm so excited. It's like a, I don't know what the equivalent would be. I'm thinking like fangirl, but fair housing is such a robust topic. And we hear from a lot of you that, things change and I'm not sure when it's at, when it counts and when it doesn't count. So we have Marley and Cicely here with us today from Northwest Fair Housing, and they're going to kind of go through some different perspectives and some information with you. And so I hope that you get a lot out of this, and kind of just the other reminder is if you have other topics that you're interested in that you want us to kind of find and host, we'd love to do that. So please email me if you've got other topics that you're interested in. Oh my gosh, you guys, I didn't even say, my name is Ryan and I'm the Foundational Community Supports Program Manager. And Dawn Miller is here. She's our Supported Employment Program Manager as well. So we'll be here to kind of help out, but kind of pass the baton over to you, Marley and Cicely.
Excellent, thank you. Good morning. I'm going to bring up our slides here. Okay, hopefully everybody's seeing that. Can everybody see the slides? Rayanne, perfect. Okay, great. Well, good morning, folks. My name is Marley Hawkendonner. I'm the Executive Director here at Northwest Fair Housing Alliance, and I'm joined by my colleague, Cicely Thompson. She's going to kick us off here, and then she and I will just go back and forth and share some fair housing information with you, some updates as different topics apply. It looks like this is a nice size group, so hopefully we can have some dialogue as well. If you have questions as we're getting to something, if it's on topic, we're happy to talk about something that's on your mind or that you've encountered at that time. If it's if we're running out of time, or if it's too far off topic, then we'll save it towards the end, or happy to talk with you off list. So you want to take it away, Cicely?
Yes, good morning, everyone. Like Marley said, my name is Cicely Thompson. I'm an intake analyst and the Equity and Inclusion Coordinator at Northwest Fair Housing. Really happy to be here this morning. Hopefully you guys get a lot out of this presentation, so we're just going to kick it off right now. So for our agenda today, my screen. So we're going to do Northwest Fair Housing introduction to when we started, who we are. We're going to talk about the protected classes, do a small overview. Hopefully everyone's aware of these, but if not, you'll get a chance to be to shed some light on it and get some interesting ideas from that and understanding. We have fair housing laws that we're going to cover. We're going to go a little bit into sex and sexual orientation, gender identity, national origin, immigration, citizenship status, disability, and reasonable accommodations and modifications under disability, familial status, and then hopefully we have time for questions at the end of that. Our mission statement here is to ensure equal housing opportunity for the people of Washington State through education, counseling, and advocacy.
Sorry, the slides are a little delayed. I think they're waking up. My computer's waking up. Give it another go here. Okay, sorry about that.
Thank you, Marley.
Yeah.
Northwest Fair Housing was founded in 1994. We serve 17 counties on the eastern part of Washington. And the other side is supported by Fair Housing Center of Washington, who does the rest of those counties. So if you are located on the eastern part of the state, then you would give us a call if you're having an issue in fair housing. Our staff, we have a small staff, but mighty and diverse, so that's exciting. We have Marley, who's on this training with me, Executive Director. We have Sharo, who's the Assistant Director for Testing and Investigation. Alfred Butler He's our finance manager. Glenda Mendoza Krieger, intake analyst and Hispanic outreach coordinator. We have Shannon Bedard, fair housing advocacy director, and then me. And then we also have also a very diverse board with members. How many members on there? About
We have seven right now.
That's what I thought. Okay, about 7 of us on the board. And then we also have a plethora of testers, depending on the season. Sometimes we need more testers and sometimes we don't. So if you're interested in testing, you can contact us at the end of this presentation. So what we're going to do now, Marley's going to stop sharing and I'm going to share a short, about 7 to 8 minute video and give you all some understanding with the Fair Housing Act and how it initially was started. Just give me one moment, please. Can everyone see my screen? Let me turn this down just in case.
Few in the nation believe that fair housing would in our time become the unchallenged law of this land. And indeed, this bill has had a long and stormy trip.
Well, I don't know what will happen now. We've got some difficult days ahead. Like anybody, I would like to live a long life. Longevity has its place. But I'm not concerned about that now. And I've looked over and I've seen the promised land. I may not get there with you, but I want you to know tonight that we as a people will get to the promised land. So I'm happy tonight. I'm not worried about anything. I'm not fearing any man.
Ladies and gentlemen, Martin Luther King was shot and was killed tonight in Memphis.
The death of the prophet of nonviolence set off the worst outbreak of arson, looting, and criminal activity in the nation's history. Washington's ghettos burned within a few blocks of the nation's capital.
The life of a man who symbolized the freedom and faith of America has been taken. And no words of mine can fill the void of the eloquent voice that has been stilled. But this I do believe deeply. The dream of Dr. Martin Luther King Jr. has not died with him.
President Johnson was willing to speak up and say, we have to pass a fair housing bill.
Hello, Mr. President? Yes, Dick. We're in trouble. We need some help. Yes? I was afraid of that.
Federal troops, for the first time since the Civil War, took up positions to guard government buildings.
Nothing's probably touchier than your own neighborhood and your own home or your own apartment. The administration, which supported the bill, said this has no chance. The other stuff is okay, but this will kill any politician that touches it.
Well, I just could not live beside them. I don't feel that they should be oppressed. But I moved here because it was a white community.
I have 2 daughters and 2 sons. And if there's too many colored people around here, I definitely will get out.
I think that, well, the property values will immediately go down if they're allowed to move in here in any number.
It seems as though our country is pulling apart into separate societies, where whites have jobs and Negroes have unemployment, where the middle class lives in suburbs and the poor are left in the ghettos, where one group of Americans looks upon another group of Americans with growing mistrust and even dread.
Then the bill went over into the House Rules Committee, and under the chairmanship of the famous Judge Smith, right-wing segregationist from Virginia, he wouldn't hold hearings on it. He would take the bill home so nobody could act on it. And we were running out of time.
Thousands flowed through the rainy streets of Memphis this day, finishing a march that Dr. King planned to lead in support of striking garbage workers.
How many men must die before we can really have a free and true and peaceful society?
Cause you're present, Lord. And I know you'll reach out and take mine. You take our hand.
The death of Martin Luther King is a tragic thing, but no legislation should be passed as a memorial to anyone.
In spite of the riots, I am going to support this legislation with all the vigor that I possess.
The laws that we pass up here are for all time. The Martin Luther Kings come and go.
The public reaction to this horror gave the sensible members of the committee a compelling argument that the House Rules Committee had to report that bill out. And I think that's how we got our bill. They just didn't dare bottle it up any longer.
And I have a dream that one day Negroes will be able to buy a house anywhere that their money will carry them.
At long last this afternoon, fair housing for all is now a part of the American way of life. Democracy's work is being done, and the bell of freedom rings out a little louder. We have come some of the way, not near all of it.
The fight still goes on because we unfortunately have the laws, but we don't have the enforcement. That we have changed, but we still have the same kinds of discrimination.
The U.S. Commission on Civil Rights said today that efforts by federal agencies to end housing discrimination have been generally superficial or incomplete.
President Carter has ordered federal agencies to use all means possible to strengthen fair housing programs.
For the first time, people with disabilities and families with children will be protected from housing discrimination.
President Reagan signed legislation today designed to toughen up the nation's fair housing laws.
Why did you take part in this demonstration today? Just because there was a huge crowd, or did you have any personal reason?
Well, I took part in this march today because of Martin Luther King and what he stood for, because this march is what he died for.
You know what he stood for?
Yes. He stood for nonviolence and peace for all men of all kinds. And I think if he died for it, I could carry out what he started.
Okay, did everybody was able to see that and hear that? Well, let me check chat. I'm sorry.
Yeah, I was looking at the chat a little bit, and somebody asked for the name of the film. Perhaps if we go on, if you have an easy link to that, you could pop that in there, Cicely. It's called 7 Days, and it is available on YouTube. It was produced by the National Fair Housing Alliance.
Yes.
Yeah, after seeing that so many times, it still gives me chills. It's pretty impactful stuff. So we're at 55 years now since the Fair Housing Act was passed, and a lot of things are different, a lot of things are the same. There was also a question in the chat about a phrase that you mentioned, testers, Cicely. So before we move on, I just wanted to share a little bit of information about what testers are. They're similar to mystery shoppers that some organizations use to send in people and test for customer service to see how well employees are serving people. Testers in fair housing are used to try and determine treatment, how people are being treated based on different protected classes. It's an investigative method that was upheld by the US Supreme Court in 1982, and a lot of fair housing organizations like Northwest Fair Housing do conduct testing. We do audit testing, just sort of sampling what's happening in our communities, and then we can do complaint-based testing too. So if somebody comes to us and feels they were denied a housing opportunity because of their protected class, let's say race, then we can do a test and have 2 different people contact that housing provider, and they'll be different in their race, if that's what the allegation is. And so we could send a black tester and a white tester. They'd ask questions: what's available? Do you have a 2-bedroom? You know, what's the application process? Just sort of open-ended questions. And then they separately report back to our testing coordinator, who looks at the information, and hopefully they're given similar information. If it's really different, then we can conduct multiple tests and see, is there a pattern of discrimination there? Or was the housing provider just having a really bad day and, you know, got some bad news or something in between the testers showing up? But we always need testers of all ages, races, national origins, etc., sexes, genders. And we do pay essentially a stipend. They're seasonal as needed employees, and they get a small stipend for helping with some civil rights investigation. So if you know folks who might be interested in being testers, please send them our way. We're always needing more. So thanks for the opportunity to give a pitch about testers there.
Okay, so now we're going to take a look about landlord-tenant laws versus the Federal Fair Housing Act. This is usually a lot of confusion, so we have another slide that's going to break it down a little bit better for everyone. Go ahead and go to the next one, Marley. Thank you. Okay, so on your left, we have landlord-tenant laws, and essentially what falls under the landlord-tenant laws is discrimination and denials for certain things. So income, lack of credit history, a low credit score, negative rental history, or source of income. So Section 8 vouchers, TANF, spousal support. Also experiencing denials and discrimination in the form of repairs or security deposit returns, things like that. Notices that you're getting for lease violations, rent increases. I know that's a huge one this past year. A non-payment of rent also has been huge this past year. Termination and evictions. Evictions is under the landlord-tenant laws. We get a lot of calls because a lot of people are either trying to evict someone or are experiencing the eviction process. Unfortunately, this is not our jurisdiction. So if someone is dealing with denial or discrimination based on these things that fall into the landlord-tenant laws, the remedy is to have legal action. So we refer our clients and callers to Northwest Justice Project, their CLEAR hotline, or their senior CLEAR hotline. We also direct them to WashingtonLawHelp.org, which is a really helpful site. Sometimes we can kind of look up some things and guide them and send them links to what they kind of want to start looking at. That's a great resource to figure out how to go about solving some issues you have under the landlord-tenant laws, possibly before you even see a lawyer or an attorney. On the other side, Fair Housing Act is what we do. the law we uphold. And this is discrimination in housing, but because of the person's protected class. So if there is discrimination happening, such as the property managers refusing to rent, the landlord treats you differently than the other tenants, you're getting harassed by one of your protected classes, the owner just terminates your tenancy because of one of the protected classes, the manager denies a person with disabilities to request a reasonable accommodation modification. We'll get into that later during the presentation. And so if this discrimination is happening to you because of the protected class, that's when it falls under the Fair Housing Act, and you give us a call. And from there, we do an intake, and we go through the process, and we would, if it is a full complaint, we will file it with HUD or Washington State Human Rights. And you have to file within 1 year of the incident. So we try to figure out, we get times down and dates and get all the details of what was happening. Try to find some evidence that it's because of your protected class. And if we're filing a complaint on your behalf, we walk through that process with you. Okay, so like Marley said, it's been 55 years. The Fair Housing Act prohibits discrimination in sales, rental and financing of dwellings, and in other housing related transactions based on the 7 protected classes. And the dwellings, sometimes people get confused with that. So here is the verbiage from the Fair Housing Act. Any building, structure, or portion therefore which is occupied as or designed or intended for occupancy as a residence by one or more families. And this also includes any vacant land which is offered for sale or lease for the construction or location thereon of any such building, structure, or portion intended for occupancy. So if it's intended to dwell in and live in, that is a dwelling. Marley, would you like to talk about who needs to kind of comply to this Fair Housing Act?
Absolutely. So who needs to apply? Basically anybody who's involved in any kind of a housing transaction. So on the left, we've got a list of entities. What I think we do have added, one of our earlier slides, I don't think we had homeowner associations and condo associations. We get a lot of complaints about those. We've got volunteer boards in those situations, and oftentimes they don't know much about fair housing, and yet they want to enforce a lot of rules and make everything uniform for everybody, and in particular don't always understand about reasonable accommodations where they need to make exceptions for people with disabilities. But landlords, property managers, housing counselors, housing authorities, anybody really involved in housing, it does not apply just to federally funded programs. It applies to private market as well. There are a couple of exceptions for smaller type landlords, but what the Federal Fair Housing Act provides for exemptions are state law against discrimination. The Washington law against discrimination really takes that away, because the Washington law only exempts these smaller landlords from having to give reasonable accommodations and modifications, but they're not exempted from anything else. So our advice is always, unless you really know, assume that the Fair Housing Act applies and the Washington law against discrimination. But there are a couple of small exemptions for smaller landlords. And here again is a list of all the kinds of transactions that are covered. There's been a lot in the news lately about appraisals. You may have seen some articles coming in from other parts of the country about differing appraisal values being given based on the race of the person in the home when in particular, African Americans ask for appraisals. And then the house is what they're calling whitewashing, where they remove all the photographs and art and anything to indicate that African American or Black people live in the home. And then it's replaced by photographs of white people, and white people are there working with the appraiser. Have been huge disparities in appraisal values. And so that is a big chunk of equity that is lost, that gets passed on from generation to generation when that happens. So you may see some more news coverage about those kinds of cases. But sales, rentals, financing, we're probably mostly going to talk about rentals today, but keep in mind that it does cover all these other transactions as well. So now we've got to the protected classes. You want to walk everybody through that?
Yes.
Okay.
So the protected classes, which in the video you guys all seen, can anyone list them or remember the 7 that were listed in the video? Go ahead and unmute, type it in the chat real quick.
We'll give them a minute. I'm looking in the chat. I'm not seeing anything yet, but yeah, if you want to unmute, call them out. Okay, I see some. Oh, here we go. Okay, familial status, yes. Race, yes. Sexual orientation and gender, yes. Those are both under sex discrimination in the Fair Housing Act, but they are listed separately as sexual orientation and gender identity in the Washington Law Against Discrimination. We'll talk about that a little bit. And again, sexual orientation being included in sex discrimination, and religion. Yep. What are we missing, Cicely?
Let's see, we have race, national origin.
Disability, right?
Disabilities on the list. Someone said age, race, disability.
Age always comes up. That's interesting. Everybody, yesterday I did a training without fail, and it's a great guess because age is protected in our employment laws. But for whatever reason, our legislators have not added age as a protected class in our fair housing laws, unless you're in a local jurisdiction, a city or county that's chosen to do that. So for whatever reason, age is not protected. Familial status, being under 18 in the household, children are protected, but not age. So good guess, but we always get that.
So the first 4 that was rolled out in 1968, and within the 7 days of Martin Luther King's assassination, and Congress passed these 4 first, which was race, color, and that encompasses skin tone, religion, and national origin, so ethnicity and heritage. Later on in the Fair Housing Act, it was amended. And in 1974, during that time in our society, it was women's rights was the movement at the time. So this is how sex got introduced to the Fair Housing Act and amended in 1974. In 1988, we had 2 additional amended disability and familial status as well, following movements that we do in society, things that people are like, oh, this isn't right. And we stand up for them. And then the Fair Housing Act had put this in the protected classes list.
So this is a little bit on how sex discrimination has been interpreted now in the Fair Housing Act to protect against discrimination based on sexual orientation and gender identity. So the act didn't get amended to, it wasn't amended to add sexual orientation and gender identity specifically, but HUD said we're going to interpret sex discrimination to include these things as well. And that comes because there was a US Supreme Court case in employment law that found that sex discrimination in employment law included sexual orientation and gender identity discrimination. And so because the laws are written very similarly, HUD said we're going to go ahead and take that same interpretation as well for the Fair Housing Act. So that is very recent, just as of 2021. It's a big deal. In Washington, we already had sexual orientation as a protected class under our state law. But if you're over in a state like Idaho, there is no statewide protection for sexual orientation. So this could be really life-changing for people there in terms of protecting people from housing discrimination in a state that does not have a sexual orientation or gender identity protection. And then sex discrimination also has been interpreted by the courts and HUD to include various forms of sex discrimination, such as stereotyping. You might think of that as treating men, women, different genders differently based on your stereotypes of what they're able to do as far as being tenants or residents, perhaps not renting a home to a woman because you think she can't maintain the property, mow the lawn, etc. Not renting to men because you think they're going to have loud parties or something, not be as clean. So stereotyping is a form of sex discrimination, as well as sexual harassment. So when a housing provider, a maintenance person, a manager, or another tenant is harassing somebody because of their sex, propositioning them, asking for exchange of sexual favors in lieu of rent or late fees or making repairs, or creating a hostile environment, making lots of jokes, sexual offensive jokes, continually asking the person out on dates, touching them, it escalates from there. Those things are all protected from, protected by fair housing laws. And then survivors of domestic violence also have rights under sex discrimination. That comes from a statistical analysis where courts have looked at the majority of domestic violence victims are women, not all, but statistically more, 90% or so. So if there's a policy that says anybody who's involved in domestic violence can't live here, and then somebody's denied housing, perhaps because they had a protection order against someone for domestic violence, that's going to have a disparate impact, a bigger impact, and keep women out of housing who've been victimized by domestic violence. So housing providers can keep out the perpetrators, or terminate their tenancies, but not the targets of the violence if they're able to meet the other criteria for residency. And then gender identity and sexual orientation, as I mentioned, were just added. So, so even though it's called sex discrimination, it plays out in a lot of different things that are protected in housing, such as these. Okay, now we're on to the Washington law against discrimination. Wow, take that away.
Yeah, so we have the 7 federal protected classes, and that's anywhere in the United States. So all 50 states, you're protected in those 7 protected classes. So we have 4 Washington state protected classes, and that varies from state to state. Does anyone know one of the 4, or anyone that Washington state specifically protects? Unmute or write it in the chat real quick. Political affiliation. That's not one of them, but
not under our state law. I've heard that Seattle, yep, Seattle protects political ideology, yep.
All right, go ahead and go to the next slide, Marley. Thank you. So in addition to these 7, race, color, national origin, religion, sex, disability, familial status.
Sorry, my computer was delayed there a second. Okay.
No worries. Sex, disability, and familial status, we have 4 for Washington. Marital status, divorced, widowed, or separated. Sexual orientation and gender identity, veteran military status and honorable discharge. And our newest one is immigration and citizenship status. So if you were to leave outside of Washington state, or a family member calls and has some questions about housing, you would want them to look at what their state protected is along it, but they do have the first 7. So make sure you're paying attention to that if you decide to rent a home outside of Washington.
There was a question in the chat about source of income, why that wasn't listed as a protected class. And it's because of where the legislature put that protection. They put source of income protection into our state Landlord Tenant Act rather than the Washington Law Against Discrimination. So it's very much like a protected class. Housing providers cannot discriminate based on source of income, and that includes subsidies, vouchers, VASH vouchers, Section 8, SSI, SSDI income, any kind of income or subsidy unless it's unlawful income. So any ill-gotten illegal gains, you can't count as your income. But beyond that, source of income is protected. But the remedy, if you feel you've been denied housing because of your source of income, is not to file a complaint with HUD or the Human Rights Commission. Instead, it's a legal action, just like if your landlord's not making repairs or is breaching your lease or not giving you your security deposit back, you have to go to court. So for those issues, we do usually refer to Northwest Justice Project, and they have been actively working with people on those kinds of cases. So source of income is protected. We do still hear a lot of discrimination that goes on regarding that, but it's technically not in the fair housing laws. And then one of the more recent amendments of our Washington legislature to our state law against discrimination is to clarify that race discrimination includes protections for hair and hairstyles that are historically associated with race or national origin. And just like the Fair Housing Act is often interpreted along the lines of employment law discrimination, what you see going on in education discrimination sometimes then is interpreted into the fair housing laws. So again, there have been a lot of news articles, news stories across the country about children being sent home because they didn't have the appropriate hairstyle, or the teachers actually cutting the kids' hair, things like that. So this has been called the Crown Act in a lot of jurisdictions. California, I believe, was the leader in that. We didn't adopt it in Washington as a separate protected class, but the legislature did clarify that race discrimination can include discrimination based on hairstyle. And then a little bit about national origin. National origin is protected under both our federal and state laws. Generally has to do with the part of the world that you or your family came from, sometimes referred to as ethnicity, includes your culture, your language, your dress, your food, all those things that go into your national origin. A lot of questions come up as far as requirements to translate or interpret for non-English speaking people. If a property is not federally subsidized, just private market housing, there is no legal requirement to provide translation or interpreting. However, it can be a best business practice if you have a lot of folks in your community that are speaking another language, might be Russian, Ukrainian, Marshallese, etc., Spanish. But there's no requirement. But you cannot have a English only policy that would violate the fair housing laws. So even private market housing that doesn't have to translate or interpret, they still have to work with people. So if somebody comes and doesn't speak fluent English, you still need to, give them your paperwork, let them take that if they want and have somebody else translate it for them. You can't say English only. And then if you're working in a program or housing that receives federal funding, because of Title VI, a different law, Congress wants to make sure that our federal resources are distributed and available as broadly as possible. So there are heightened requirements to provide translating or interpreting. There is a language access plan guidance memo from HUD that goes more into that, what's required in terms of interpreting and translating. And there are usually safe harbors in there. And I believe it's around 5%. So if you have 5% or more of your community, your housing residents, your program participants that are speaking another language, then all of a sudden it kicks you into the area where you need to start providing some of the more critical, important documents in translation and providing some interpreting. So,
Marley,
yeah.
oftentimes a national origin can also fall on students from different countries coming over. Can a landlord say no students in their advertisement for their rental?
Technically, they can. This gets a little tricky. We've had one case in the past, but yeah, because if you're not sure if something's protected or not, try and look at what's the opposite. So if you say no students, who's going to be discriminated against? Students. Students themselves are not a protected class. Now, if you said no international students, no students from a certain part of the world, then you're into national origin discrimination. But generally, students are not a protected class, and we do hear from some housing providers in college communities in the state that want to rent to students, and sometimes there's local zoning issues that come up about that. So, but students themselves are not a protected class, but if you link that to a national origin, they are. And then related but different is immigration and citizenship status. So this was added recently by our Washington legislature, and it's similar to national origin. There can be an overlap, but this is a legal status. This is a status that sovereign nations give to people when they come into their borders. And so Washington has chosen to say that you cannot discriminate against somebody because of their immigration or citizenship status. And that includes all these forms listed here, whether they're an immigrant, a naturalized citizen, born here, just here on a work visa, a student visa. They cannot be denied housing. There is an exception, however, for programs that receive federal funding and have federal requirements, because this is a state law. It can't preempt anything that the feds have already required. So usually with subsidies like Section 8, there are often limitations on how much can go to the household for funding for the subsidy based on the makeup of the household, if people are have documented status or not. So you still, if you're in a program a federal program like that, you need to follow those rules. But otherwise, private market housing providers should not be inquiring into people's immigration or citizenship status and making determinations on housing opportunity because of that. So it's different than employers that have to, have you fill out an I-9, look at various forms of ID, verify that you can lawfully work here. Housing providers don't have that obligation unless it's a federal program specifically. These are some forms of alternative IDs if somebody does not have a social security number. This comes from an internal Washington State Human Rights Commission guidance memo. So there's different ways that you can try and verify somebody's identity, or that they have the ability to pay or have income, even if they do not have a social security number. And tenant-on-tenant harassment based on immigration status is certainly unlawful, as is harassment based on any kind of protected class, but this is specifically included in the Human Rights Commission memo, as is things like threatening to call ICE if somebody asks for repairs, or charging people higher application fees or rental rates because of their immigration or citizenship status. Now we're onto the big one here, disability as a protected class. We have more complaints filed in this country, in this region, in our office, based on disability than any other protected class. And I think there's several reasons for that. We're an aging population. So as we get older, we're more likely to incur disabilities, and more of us are aging and developing disabilities over time. There's more provisions in the fair housing laws that pertain to people with disabilities, like reasonable accommodations and modifications, as well as design and construction requirements for accessibility. And so there's just a lot more areas where things can go wrong and complaints can be filed. Probably 80% of the people who contact us for assistance have someone in their household with a disability. So we do a lot of advocacy and education in this regard about accommodations and modifications. You want to talk a little bit about this?
Yeah, so essentially reasonable accommodations and modifications are a tool to balance the scale, so people with disabilities that require special needs can have equal access and equal opportunity to use and dwell in their home and their common areas. The definition of disability, physical and mental impairment, which substantially limits one or more major life activities, or a record of such an impairment. and being regarded as having such an impairment. This is the definition in the Fair Housing Act. So there's a little broader definition in the wall ad. So it includes temporary and mitigated medical conditions, because you could become disabled for a short amount of time, like this woman in the picture. Her leg, she's disabled right now because of her leg, but her leg can heal over time, and she could be not disabled after this. So it just covers temporary and mitigated medical conditions. And also I'd like to throw in there high risk pregnancy is also covered if it's high risk. That's temporary disability as well. So a reasonable accommodation is an exception to a policy, rule, practice, or service needed because of a disability. It needs to be reasonable. So it's not reasonable if it would impose an undue financial administrative burden on the housing provider, or it would fundamentally alter the nature of the housing provider's operations. So again, a reasonable accommodation is an exception to the policy, rule, practice, or service needed because of a disability.
And things that might fundamentally alter the nature of your program might be if you're not involved in providing supportive services, supportive living, and somebody asks you to take them to the grocery store, come in and administer their medications, or help clean their house, or something like that. Those things are probably not the normal part of a housing provider's business unless they're involved in providing support, some kind of supportive housing services.
So who can ask for an RA? A person with a physical or mental disability who is needed because of the disability, and it is reasonable. So those three things have to be met for you to ask for an RA.
So throughout any kind of reasonable accommodation analysis, just keep these three things in mind if you don't remember anything else about accommodations. You need to have a disability. What you're asking for has to be related to the disability. You can't get anything you want, but there has to be a connection to you need it because of your disability. And then, is it reasonable? And there are all kinds of fact situations that come up, different things. A lot of them come up over and over, and we kind of know where the courts and HUD will interpret the reasonableness, but you have to just analyze each one separately as they come in. So how do you know if somebody has a disability? HUD would say if it's obvious, if they're using a wheelchair or say a red and white striped cane, somebody is blind, using a seeing eye dog, you take it at face value. You don't make them go to the doctor to get a letter that says I have a disability if it's obvious. But there are a lot of invisible disabilities where somebody doesn't appear to have one, but they very well may. And so in that case, third-party verification can be requested to verify that the person has a disability. So I'm not sure if we have another slide coming up on the verification, but
I believe we do.
Okay.
When must a reasonable accommodation be granted? The person has a disability. There is a nexus between the disability and the accommodation, and it is reasonable. So again, with the three things that Marley said to remember, the reasonable accommodation, it must be granted, disability, nexus to the disability and the accommodation, and it's reasonable. What is this one?
Oh, if somebody is reporting showing SSI or SSDI income, they're going to be covered as having a disability under the Fair Housing Act, because it's harder to qualify for those programs under the Social Security Administration than meet that definition of disability for the Fair Housing Act. So through the application process, or somebody shares information of that, that's verification right there that they have a disability, the income.
When can a reasonable accommodation be requested? And that is any time. So in the beginning, before you move in the middle of your tenancy, or near the end of your tenancy, you can always ask for a reasonable accommodation if you meet the criteria.
Yeah, needs change. You might not need it when you move in, and then you develop a disability, or it worsens, or your needs change.
So the request does not have to be in writing, but we highly recommend it. The request should state that said person has a disability and needs the reasonable accommodation because of the disability. And please allow me to have whatever is needed for the disability. So if that's a service animal, a reserved parking space, or anything else you might need due to your disability has to be listed in the letter. And again, we strongly recommend that it is in writing, but it doesn't have to be.
And it doesn't have to be on any specific form. So housing providers can offer forms to be helpful, but they can't require that people use those forms. If you already have a letter from your doctor or a healthcare provider that spells out the accommodation that you need, that you have a disability, you shouldn't have to go back to the doctor and get yet another letter. And we do encourage housing providers to not contact the healthcare providers. Put that on the person who's asking for the accommodation, so that you don't call up and start asking about the nature or severity of the disability. You're going to run into HIPAA issues probably anyway. So it's best to just say, sure, we give reasonable accommodations, or if you're helping somebody with an accommodation request, that they contact their healthcare provider and come back with the letter or whatever, verifying, so that housing providers don't have to play detective and try and do that verification. They can offer it as a helpful assistance. Would you like us to fax this over? Would you? But they can't require it. So it's just easier usually if you say we give reasonable accommodations, but put the burden on the person who needs it to interact with their healthcare provider to get their verification letter. Before we get into these examples, there was one question I saw in the chat that was asking again about the reasonableness, the third factor. How is that determined? Essentially, you look at what would be unreasonable. So something is unreasonable if it would be a financial burden on the housing provider, cost them a lot of money to make the accommodation, or would be a substantial administrative burden, cause you to do tons of paperwork on a recurring basis, or if it's a fundamental change to your program, again, like providing supportive services when you're not in a supportive services program. So first you look at, is it unreasonable for any of those reasons? If not, then if it's not going to cost money, a lot of deviate from your program substantially, or cause a lot of paperwork, it's probably in the reasonableness realm, but it's very case specific. And we look to the things usually that come up over and over again for guidance. And then if it's something completely new, you just have to, look at, is there any reason that this would be unreasonable? And if not, then presume that it is reasonable. But here's some of the examples that come up over and over. You want to go through a couple of these, Cicely?
Yeah, and real quick, there's also a question in the chat. Does this include emotional support animals? And yes, it does. I know there's several names for emotional support animals, therapy animals. I like to joke around and say people just call them their buddy and say that they need them. But if they have a verification saying that they do need this animal, then that is valid for them to use that for. So it varies.
Yeah. Staying on assistance animals for a minute, really the analysis is just the same. Do they have a disability? Do they need X, the animal? Is it reasonable? Did the animal, bite people and destroy people at the last unit? If not, then it's probably a reasonable accommodation. But there's a lot of confusion because there's other laws that govern use of animals for disabilities in public spaces, like the air carrier laws. We all see on the news occasionally somebody gets on a plane with a turkey and causes a big uproar or something, and that might be interesting or entertaining, but that doesn't have any bearing on housing law for assistance animals. Same with the ADA, the Americans with Disabilities Act, allows service animals in public spaces like grocery stores, restaurants, etc. And those are specifically defined and limited to trained dogs that are trained to perform a benefit or service, a task for somebody with a disability. The seeing eye dog is the most obvious, but it could be providing balance or hearing alert, things like that, as well as miniature horses. That's the only other animal that's allowed in public spaces under the ADA. They apparently are smaller than a lot of the big dog breeds, and they live about 3 times as long, so you don't need to train them over and over, and apparently can be housebroken. So we may start to see more miniature horses in the future. But those are the only two animals allowed in public spaces, and they have to meet that training definition. Once you go into your home, it's different. You know, your home is your castle where you can, you know, kind of relax, and you're not infringing on other people the same way as when you're sitting by them in a movie theater or something. And so there's a lot more latitude given. So assistance animals in housing can be cats, birds, ferrets, gerbils, etc. They can be just for emotional support. They don't have to be trained to provide a specific task like service animals out in public. So it's just that same analysis, the 3 steps. Do they have a disability? Is the assistance animal needed for their disability, regardless of what they call it? They might call it a service animal, a buddy, a therapy animal, etc. Doesn't matter what the animal's called. It's the person. Do they have a disability and a disability related need for that animal? And then is it reasonable? And the things that go into that, again, are usually some kind of past behavior. You can't assume because of the species, the breed, the size of the animal that it's going to be dangerous if you don't know anything about that specific animal. So a lot about assistance animals come up.
Yeah. Well, thank you, Marley, for that.
Yep.
So now we're going to look at some examples of reasonable accommodations. And so essentially the rule is first come, first served parking. And what you're asking for is a reasonable accommodation for exception of the rule. So you're asking for a reserved parking spot due to disability.
Yep, that one comes up over and over, huh?
Yes, it's very popular. And this is a reserved parking spot for this person, not the reserved parking spot for disability that a lot of the paratransits pull up to. Those ones stay empty in the sense of that it's frequently used by multiple people throughout that apartment complex and or home. So you would want your client and or you are asking for a reserved parking spot for your car to be, and not in one of those reserved parking spots for disabled paratransit and things like of that nature.
Again.
Another one is the rule is no occupant except leasee, but you are asking for a live-in caregiver for a reasonable accommodation. And this is okay for you to ask, even though this person isn't on the lease. There will be a background check. So just keep that in mind. Whoever they're asking to have as their living caregiver does have to go through background checks, but they are not going to be put on the lease or shouldn't be put on the lease because they are not financially responsible for your unit, but they also must follow all the tenant rules and laws while they're living there caring for this person.
Yeah, this can come up in like a 55+ community. Maybe you have a caregiver who's younger, and that's an exception to that rule for the 55+ community to have somebody help you for your disability. It's often where that comes up.
Another reasonable accommodation, the rule is no lease break and penalty. So you're going to be asking for early lease release due to disability with no financial penalty. And this happens. Sometimes you might become disabled at some point in the home that you are living in. It is not allowing you to dwell comfortably in your home. So you might need to break your lease due to disability. 60-day termination due to disability that you need to extend your tenancy, excuse me, and have a little bit more time in getting some things together so you can move out of the unit. So you might ask for a 30-day or 60-day extension, but does not mean that you are going to be living there indefinitely. So you do have to follow what you do ask for. So if it's 30 days, you need to be out in 30 days. If it says 60, be out in 60.
And you have to pay rent. You don't get to live there for free.
Yeah. So the rule here is the rent is due on the 1st, and a reasonable accommodation, like we were saying earlier, you could verify disability through SSI and SSDI. The exception is to change the rent due date to match when you get your SSI or SSDI check. So say you get it on the 5th and you need until the 10th or possibly the 15th to get the money order and send it in, those kind of things. Maybe you have to pay it online and you need to travel to the library, and due to disability, it slows you down a bit. So you very well can ask to change the date to match that for you, so it doesn't become a burden for you to change or to pay your rent.
I was just reviewing the last year of fair housing cases that HUD has had some actions on. I like to do that each April and take a look back. And there was a case that had to do with a couple of tenants not being able to change the due date. Their prior manager had allowed them to pay on the 5th, I think, instead of the 1st, and didn't give them a late fee for that because that's when they received their disability income. After 7 years, the manager changed, new manager came in and said, no way, gave them late fees, refused to make the accommodation for them, and then ultimately tried to terminate them. And there was a complaint filed, and it did go against the housing provider. So they should have made those accommodations. Okay, here's our assistance animal slide. We already gave a bunch of info on it, but I did see a couple comments in the chat asking about breeds and insurance. So housing providers can have rules. So you can have a rule, you know, no pets, no dogs, no Rottweilers, no of this certain breed. But an accommodation is an exception to the rule. So the rule might be no pit bulls, but somebody comes along with a pit bull as their assistance animal, and there's nothing to show that that particular pit bull has been dangerous. If they've already met the other requirements of having a disability and they provided verification that they need that animal, then the accommodation should be granted. So that's an exception to the rule. Sometimes people have insurance policies for the property that have dangerous breeds, breed prohibitions. But remember, insurance is covered by the Fair Housing Act. And so HUD has a memo that it's about a 2-page memo, and it says that if a housing provider gets a request for an animal that's on an insurance dangerous breed, and they cannot get comparable insurance elsewhere, or it would be substantially more expensive, then they can say this is an undue financial hardship. That goes into the reasonableness. But they can't just say, oh, we don't accept that breed, or our insurance doesn't accept that breed. They have an affirmative requirement to, you know, shop it around with their broker, ask, you know, can we get an exception for this? Can I get alternative insurance? What's that going to cost? If they would actually lose insurance or have to pay significantly more, then they can deny it and say it's an undue financial hardship. But that HUD memo says that those insurance companies then can be referred to Department of Justice for investigation and enforcement. So really, if you're running into this, you know, by faxing over that 2-page memo or something to the insurance company and saying, hey, you know, we in our program or housing need to make this exception, and you guys as an insurance company do as well, that can often open the door there. So they can have a rule about it, but an exception is, if it's needed for someone with a disability, needs to be made. And that third part, reasonableness. Now, if that specific pit bull has been known to bite people and, you know, be very aggressive, then it might be unreasonable to allow that specific animal. But HUD has a very lengthy, about a 19-page guidance memo on assistance animals. And they do say that you cannot make stereotypes or assumptions about breeds. You have to look at the specific animal. So, and then last thing about assistance animals I didn't mention earlier was housing providers can't charge pet fees, pet rent, pet deposits for assistance animals. They can do that for pets, but not for an animal needed for a disability. However, if the animal actually damages the unit, then the tenant's going to be responsible for the damage, just like if they break a window or spill wine on the carpet or something like that. So, okay. there's just, I think we've probably gone through all this. Once you do get approved to have an assistance animal, it does need to be under your care. It can't be, and control. It shouldn't be jumping on people, running at large. A lot of times people think, well, I need it for my disability. I was approved to have it here. Now it can do whatever. No, that's not the case. Animal can't be running all over, jumping, biting. It needs to generally be on a leash, in a cage, somehow under the person's control. So otherwise they can get compliance notices for behavioral issues.
How many reasonable accommodations can a person request? This is unlimited. They are case by case. And ignoring or delaying a response could be perceived as discrimination. So if you're on the other end and receiving a reasonable accommodation, you would want to respond to that because after a while, it can be perceived as discrimination.
And I see somebody asking for a link to the memo. We'll try and follow up and send those memos, the assistance animal and the insurance memo. We can send those on to Rayanne, and she can hopefully share that with you. And you can always feel free to reach out to us too, but we'll try and remember to follow up with that. So this is the verification slide that I was wondering about earlier. Yeah, so if it's obvious, don't make the person go get a letter that says I have a disability. But for an invisible, non-obvious disability, HUD says that you can ask for a third-party verification. And the examples that they give in, again, there's another memo. It's like, I always say this in trainings, it's like that old commercial. There's an app for that. There's an app for that. There's a memo for that. HUD has a lot of memos, which is helpful. But in the HUD reasonable accommodation memo, they say that the verification can come from a doctor, a medical professional, a peer support group. That might be like a Narcotics Anonymous, your sponsor, or something like that. A non-medical service agency. That's maybe a disability rights advocacy organization, a caseworker, a social worker. It can be your counselor, therapist, or a reliable third party who's in a position to know about the disability. And really that could be anybody. Who's best to know about your disability? Probably your household members, your family, your neighbors, your friends. However, if a complaint is filed, investigators are going to look at those people as biased witnesses. And so usually having somebody at a little bit more arm's length professional relationship is going to be better verification of the disability. So can ask for third-party verification, but does not have to be a medical doctor. A lot of people think that.
The housing provider shouldn't ask for details about the disability. They shouldn't ask to see medical records from you and or the client, or call your healthcare provider and ask questions about your disability and treatments. This is not okay for them to do. They should accept the third-party verification that is given by your doctor or your medical vouching person, so the third-party verification. So they shouldn't be calling and asking detailed questions about your disability.
And one question in the chat went back again to emotional support animals. And just to, as I'm trying to monitor those just to make sure that we get to them, the question was, does HUD have any laws about emotional support animals? And the Fair Housing Act and its regulations don't mention animals of any kind. So it is not in there whatsoever. It's the three-part reasonable accommodation analysis, whether it's for a service animal, an assistance animal, whatever it's called. It's just, is it needed for the disability? What HUD has provided is though a 19-page memorandum, and that again is something that we can try and get over to Rayanne. It might be on our website too, but we can try and send that over as well. That goes through kind of a Q&A of how you would analyze a request for an assistance animal. So that's the best that we have from HUD, is that guidance.
So can a housing provider make a tenant accept a different accommodation? And the answer is no. May suggest ideas for other accommodations, but tenants don't have to agree if it won't meet their disability needs. So they can't tell you, oh, we'll just take this instead, because that would be a different accommodation and it might not fit the person's disability needs.
Yeah, HUD calls that an interactive dialogue. They want a housing provider to not just say, nope, can't have that. They want this dialogue where you discuss, well, we don't have that parking space that you want available, but we have another one. Would that meet your needs? And it might, and hopefully through some discussion, they might be able to reach a resolution that works. Now we're on to reasonable modifications.
So a reasonable modification is a structural change needed because of a disability to units and public common areas in a dwelling. So let's look at a few examples here. Reasonable modification. So we have a wheelchair ramp, oftentimes can benefit the whole community if put in. We have stripes on the stairs for so you can see them visually better. We have a roll-in shower and grab bars put in the shower. Then we have an alarming light for someone who might be deaf and need to visually see the emergency. And then doorknobs, transitioning to more of a handle or a push release rather than a turn, because someone's emotional support animal, assistance animal could very well open a door and help assist their person if it is a different kind of handle. So that's always helpful. Who pays for the reasonable modification? With this wonderful picture right here, it's your pocketbooks. So it's usually made by the resident, the tenant who's asking. The exception is in federal funding housing facilities, the landlord would be responsible for the cost and installation unless the modification is unreasonable. So, and federal funding housing, if someone said, I'm on the third floor in a unit, and for my reasonable modification, I need the property management and landlord to put in an elevator so I can get to my third floor unit. So that is could be viewed as a financial burden. So this would be unreasonable, and maybe the person would like to ask for reasonable accommodation and move to a bottom floor unit or be put on the list for a bottom floor unit to help with their disability rather than putting in an elevator for the whole place, because it's just a financial burden.
Sometimes the VA is pretty helpful at providing financial assistance for ramps and things like that. Sometimes there's some charitable organizations that provide assistance with ramp installation. But if it is federally funded, then there's hopefully something built into the budget to anticipate things like maybe having to put in a grab bar in a bathroom, something that's not super expensive, like the elevator would be the undue burden, but minor things like that would be reasonable if federally funded. Before we go to familial status, I just did also want to say that there are some design and construction requirements built into the Fair Housing Act that apply to multifamily properties with 4 or more units as of 1991, March of 1991. Anything older, all our old housing doesn't have to meet any kind of accessibility requirements for the Fair Housing Act. But after 1991, if there are 4 or more units in a non-elevator building, the ground floor units need to be on an accessible route. They can't have stairs going into the ground floor units. You need to have levers instead of handles. The door widths, the sidewalks need to be a certain width so that someone with a wheelchair can navigate them. There needs to be sufficient turnaround space in the bathrooms and the kitchens, those kinds of things. But that's very technical stuff. So if you get involved at all in developing affordable housing or any kind of multifamily housing, really make sure that the architects, the contractors, the builders, everybody you're working with know about the Fair Housing Act. So.
Also, I wanted to throw in that keep in mind that when you vacate the unit, you might have to restore the unit back to what it was. Sometimes it doesn't happen. Maybe they will be okay with the enhancement or whatever you had put in there, but for the most part, you will be responsible and to return the unit how it was. So save those doorknobs that you might remove, pack those away so you can put those back on when you're out of there. So just keep that in mind that you might have to restore. So like a walk-in shower, a roll-in shower, it's great, but the management might not want that and ask you to restore that, which costs more money for you to go back the other way and, you know, put in a tub and those kind of things. So keep that in mind as well.
Yeah, it's best to have in writing, if you're involved at all working with somebody on a reasonable modification request, to put in writing what the expectation is at the end of the tenancy. We did have a case like that where a gentleman had a 10-year tenancy. During that time, he requested and obtained permission from the manager to put in a roll-in shower at his expense, which he did. And then just 1 month before he was moving out, had given notice in his tenancy, the management company changed and he went ahead and moved out, and then they dismantled the shower, took it out, and sent him a bill for about $3,000. And so then we had this, you know, big factual argument was you can't ask people to return the unit if it's not going to interfere with future tenants. So if it's something minor, like you've reinforced the bathroom walls or something for grab bars, you shouldn't have to rip out you might have to take the grab bar off, but not take out the backing. But in this instance, you know, was a roll-in shower an enhancement or not? You know, somebody with a disability might not want that. On the other hand, it might be a really marketable feature in, you know, a time when we don't have a lot of accessible housing. So to avoid that kind of dispute, try and get the agreement in writing, what's expected to happen, so that you don't have that conflict later down the road. So I know we're coming up on time. We have about 9 minutes. I want to just go through a little bit about familial status, some of the things that could come up there with children under 18. Steering is prohibited based on any protected class, but we often see that where families with children are steered to one floor, one building, the lower floors. Can't do that even if it's well-intentioned, or steer people away saying, you know, you're not going to be comfortable here. There aren't a lot of children, but if you look up at that place up the street, they're by the park, they're by the school, you might like that better. Even if it's well-intentioned, just, you know, don't do that. Just tell people what's available. There's a, you know, a 2-bedroom or whatever. Can't segregate the units based on age. People shouldn't refuse to rent because of safety concerns. Everything should be built to code. Parents have to make a lot of decisions. Are they going to live in a high crime area? Are they going to live near a busy street? Are they going to live on a second floor? And if it's built to code and they choose to live on a second floor, then that should be their prerogative. They should be told about all available units on all floors. No children should not be used in advertising. We still do come across that sometimes. Rules should be drafted in a neutral manner rather than, you know, no toys in the common areas. You should have a rule like, you know, no personal belongings left in common areas, or quiet hours for everybody after 10 p.m., not curfew for children at, you know, 10 p.m. Because if there's a familial status complaint and the rules are all about nitpicking about the kids, it doesn't help. So the rules should be drafted neutrally, should be applied neutrally, so that, you know, if people without kids are having loud parties and they're, you know, they should get compliance notices, as well as a family that's maybe being excessively noisy. When it comes to health and safety, housing providers can have some really narrowly tailored rules, but they have to have a really good reason for that. If they said nobody can use no kids in the swimming pool ever, that's going to be way too restrictive. But if they follow, like, for example, we have a Washington law about our public swimming pools. Children under 13 need to be accompanied by an adult over 18, but children 13 to 17 can swim with a buddy. So that's allowing access and safety at the same time. So this can come up with, you know, swimming pools, jacuzzis, weight equipment, look to manufacturers' guidelines, you know, gym requirements. You know, does CPS have a requirement? You know, should a kid who's 2 be out on the playground alone? Probably not. But should a kid who's 14 be kept from being out there alone on the playground? You know, no, I don't think so. And in my review of cases, there was a case, a big one that involved, I think that one was like a $3 million settlement, involved multiple properties, about 30 different apartment complexes, and had to do with a requirement that kids could never be unattended outside, never. Any age couldn't be outside and play, and unattended, and couldn't be anywhere on the premises under 14 unattended, so you couldn't send your 13-year-old to go down and get the laundry out of the laundry room for you or something. That was way too restrictive. And so that ended up in a big settlement agreement. Again, I think that was in millions of dollars, involved a lot of properties. But yeah, that's happened there was a VOA, not in Washington, but a Volunteer of America program that also got hit with a similar complaint. They just had a very restrictive policy. And we've come across properties in Spokane that are like that, where the kids weren't ever allowed to be unattended. They had to sit inside during those hot, sweltering summers here, not outside making friends. And it was pretty well documented in text messages and notices about the policies. And so we did file some fair housing complaints on that. So rules need to be really narrowly tailored and should only be for, like swimming pools or hot tubs, and allow as much access as possible. As far as who can live in a unit, generally housing providers shouldn't have rules about, no kids under 6, or we only want teenagers, or only boys or only girls, or who can share a room or not share a room based on age and gender. Once the household is qualified overall to be in the unit, let the family figure it out who's going to sleep where, and it shouldn't matter what the ages of the children are. There can be some limited occupancy. There can be some occupancy standards, but not based on children, just on total number of people. And HUD, again, there's a memo for that, has guidance that says 2 per bedroom is reasonable. So anything less than that, if it's a one bedroom and only one person's allowed, that's going to be very problematic and probably violate fair housing laws. But 2 per bedroom, and then +1 is a good safe harbor. So that allows for, an infant that comes in, a child placed through kin care, a fostered child, whatever. So 2 per bedroom +1 would be 5 people in a 2-bedroom. 2 +1. But it shouldn't factor in the ages of the kids, the sexes of the kids, anything like that. There's a limited exception for senior housing. Congress enacted HOPA, Housing for Older Persons Act, which allows 3 types of senior housing or housing for older persons, which if these requirements are met, then the familial status provisions of the Fair Housing Act don't apply, and they can discriminate against children. The 3 types are HUD housing, so elderly housing, housing for elderly and people with disabilities, you often see. So if it's a HUD program, again, that is permitted to not have children if it's for elderly people. 62 and older, that can be private market housing, not just HUD housing, but 100% of the occupants need to be 62 or older. And then where there's a lot of confusion is this 55 and older exception. And again, this can be any kind of housing, private market or not. But to be 55 and older, 80% of the units need to have one person over 55. So an easy math is you have 10 units, 8 of those need to have somebody 55 or older. If you fall below that, you lose the exemption. To make sure that you're still at that level, the housing community needs to do a survey every 2 years and verify that they're still at that level, and needs to publish rules and advertising that show an intent to be for 55 and older. So it's not just like an excuse that they made up if a family files a complaint and says they were denied housing because they have children, and the community says, oh no, we're 55 and older, and there's nothing to show that. So really it should be in their bylaws and their rules and their advertising. And the advertising should be for 55 and older or senior housing, not adults only, because an adult is 18 and over. There's no adult only housing. Shouldn't be 40 and over. We've had cases like that. So there's no place that you go and get a stamp that says you've complied with the 55 and older exemption, though. It's just an affirmative defense. If a familial status complaint's filed, the community pulls out its stack of paperwork and says, no, we're 55 and older, and this is how we prove that we were. So, but we get a lot of cases in that area. Do you want to summarize here?
So in summary,
yeah,
that was a lot. So I see some people in the chat have to leave. So if you need to leave, go ahead and head on to your other meetings. So the summary, though, is the Federal Fair Housing Act prevents housing transaction discrimination based on the protected classes. Washington state law against discrimination does this as well and covers the 4 additional protected classes. And lieutenant laws are often self-help, as they are self-enforced and require legal advice and legal action. and or court. People with disabilities have extra Fair Housing Act protections with the reasonable accommodations and modifications requests. So that's just a summary. Hopefully, majority of this information sticks with you, but if not, here's just some 4 bullet points that you can screenshot that can kind of keep you on the right track when you're trying to assess fair housing issues.
There's a couple comments I'll get to real quick. If you have to go, I understand, appreciate it, but I just wanted to address a couple of the comments I saw there. Somebody said that a landlord said they couldn't put more than 3 tenants in a 3-bedroom apartment. To me, that sounds like a fair housing violation. So that might have been the policy that they enacted or what they thought they had to adhere to. But if you're talking about a 3-bedroom apartment, 2 per bedroom would be 2, 4, 6 people, and a +1, I would say at least 7 people in a 3-bedroom apartment. So I'd be really interested in that as a fair housing investigation. But you can certainly try and educate them that that doesn't comply with the fair housing law. Somebody had a comment that a training just on assistance animals would be great. We'd love to come back and do that too if you want. But I'll make a pitch on our website, nwfairhouse.org. We have a training page, and on that training page are links to a bunch of on-demand courses that you can take 24/7 any time of day. Most of them some of them are free, some of them are about $25 a session. But if you just need a quick, we have one on assistance animals. So if you want to really dive into that, we have about a 45-minute training on assistance animals. If you're onboarding new staff, they're a great resource to, if you don't have time to get a whole training for a bunch of people, to get somebody a quick class. So that's a resource I wanted to share. Any other questions? Anybody want to unmute or ask a question or ask us to comment on something we didn't get to earlier? Scanning the chat, trying to see if there's anything else that we missed, but anything we didn't answer or any other questions you have?
Can you provide again the context or the at least the organization name for Western Washington, your counterpart?
Sure, it's Fair Housing Center of Washington, and they are based in Tacoma, and they serve Western and Central Washington.
Well, so while people are thinking about whether they have other questions, I wanted to say thank you so much, Cicely and Marley, for your wonderful presentation. Really, really good. I'm Dawn Miller. I'm the Supported Employment Program Manager, and I will pass along to Rayanne that that there's another webinar request for you to come back and present. I'll let her know about that. If you'll send your slides to Rayanne, and then the memos that folks were asking for, I know Rayanne will be sending those out along with the recording link once that's downloaded. So thank you so much for doing such a wonderful job today.
Thank you so much, Dawn. Thank you for having us. And thanks everybody for your time and your fair housing lenses and yeah, taking time to be here with us today.
Time well spent.
All right, anybody else? Anything else? Okay, well, thank you all so much. Really appreciate your time.
Yes, thank you all. You have a wonderful day.
Happy Fair Housing Month.
Take care.
Bye-bye.